Mr. Wara, state your name for the record.
Joshua Wara.
All right.
And this is a date and time I had set preliminary examination in this matter. My understanding is you would like a forensic evaluation.
That is correct, Your Honor. Based on my conversations with Mr. Wara,
Forensic evaluation for what? What's going on here?
based on my conversations with Mr. Wara, I believe that it is necessary.
Hey, I'm representing myself. What are my charges? What am I in here for? I'm representing myself. I don't need a barcode to represent myself. What am I in here for? What charges am I on here for?
Right from the start, you can feel the tension here. The defendant is confused, defensive, and clearly frustrated. Instead of calmly asking about his charges, he's challenging the system itself. This is already a red flag in court, because judges pay close attention to how defendants communicate under pressure.
I don't need a forensic exam. I'm not mentally disabled. I have ADHD and PTSD. I'm perfectly fine. I'm not on Social Security.
Sir, you are before the court on a felony complaint that alleges that on or about, as I read to you before, October 15, 2025, location of South Main Street and East William Street in the city of Ann Arbor, Washington County, state of Michigan, that you did fail to stop at the scene of an accident resulting in serious impairment or death of an individual.
The guy was
That is a
perfectly fine.
felony. That is a felony, punishable by up to 5 years incarceration and a $5,000 fine plus court costs. You do understand that, sir?
I understand that. Thank you,
Correct.
Mr.
Count
Simpson.
2 on that complaint alleges that on that same date and at that same location that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yeah, I understand that.
All right. So that is what you are here for.
Mr. Simpson, I'd like to subpoena the camera footage from the mobile gas station there on North Main Street that I was at, or on South Main Street where I was at, over on South Main Street in Maynard. My car was parked there the whole time. I accidentally hit the guy. They hacked the light using an AI.
Sir, Mr. Warren, I'm going to suggest to you this. That refrain from saying anything, because anything you say can be used.
Oh, I know. They used an AI ethical hacking app, the Tomboys and the Ku Klux Klan, and they had broken my glasses when I wasn't. They took my car for a joyride and broke my glasses while I was at St. Joe's Hospital.
Now this is where things take a dramatic turn. The defendant begins making claims about AI hacking, stolen cars, and secret plots. In legal terms, statements like this can seriously affect how the court views competency. Judges aren't judging intelligence here, they're judging whether someone can rationally assist in their own defense.
The Klan did?
Huh? Yeah, the Ku Klux Klan. You can subpoena video records, and I subpoena the security guards from St. Joe's Hospital, Trinity Hospital.
That's one of the reasons, sir. That's one of the reasons why you have an attorney. Did you let them know that?
No, I don't have an attorney. I told them I don't want anybody to represent.
wanna
I said I'm
represent
representing
yourself?
myself. Yes.
Is that what you want to do?
Yes, I would like to do that.
Sure.
And I would like to
I
subpoena the
do
camera
have to
footage from
advise
mobile
you,
gas
now
station on
knowing
Main.
what the
South
charges
Main.
are, sir, that if you elect to represent yourself, you'll be held to the same standards as an attorney would regarding the rules of evidence and procedure in the courtroom.
Yes, Your Honor, I
And
understand
would
that.
not be shown any favoritism.
Yes, and I would
If
like to subpoena my
at
discovery
some
packet,
point in
please.
time you wish then to be represented by counsel, you need to make that request to the court.
Okay, I've
to
tried
do
calling the
that.
public defender's office, and I've tried to tell them I want to represent myself. And I've tried to subpoena my discovery packet, and they won't bring it to me. I need to subpoena my discovery packet for all cases available, please. And I would like, yep, and I would like to also subpoena everybody's address in the MDOC that's involved in the Neuralink case through Secretary of State, phone numbers, text messages, and visual voicemail records. And I would like to subpoena the phone recordings, Securus GTL recordings from when I was in the MDOC at ARF level 4. And WCC pictures and.
Sir, I have listened to you both through the last hearing and this hearing. So what I'm going to do at this point is I'm not going to relieve the public defenders, but I am concerned, while you have indicated to me that you don't need a forensic evaluation, the court, in listening to you, does believe that you would need a forensic evaluation.
No, I'm
For your
perfectly fine,
own,
Mr. Simpson.
Sir, for your own
I'm not on Social
protection and
Security.
preservation of your rights.
This moment is crucial. The judge isn't trying to punish him, he's protecting the case. If a defendant isn't legally competent, anything that happens next could be overturned. Ordering a forensic evaluation is about safeguarding constitutional rights, even when the defendant strongly disagrees.
I'm not on Social Security. I'm over the age of 25. I'm not mentally disabled. I do not need a forensic
And sir, here's the
investigation.
thing.
I do not
I
go
have
to the
to,
forensic center.
I have to, in terms of these proceedings, make sure that you are competent and.
Oh, I'm
that you
very
know the
competent, Cedric Simpson. You can tell. I'm very
Thank you, sir.
intelligent.
You
I have a
can name
GED.
that
I got a
judge
GED in
GED.
2013 in 3
Okay,
months.
all right.
I got a GED from Washington Community College Adult Transitions Program in less than 90 days in 2013. You can subpoena that record. If someone can get a GED in less than 5 months, I'm pretty sure they're competent. And I would like to
Well,
subpoena my GED from the
Here,
Adult
then
Transitions
you can
Program
do
in
that.
2013
You
at
can-
Washington
you
Community
can draft a
College.
subpoena. I will not relieve the public defender at this point, but I will consider certainly that once the.
Thank you. Yeah, that way,
Forensic
if you see I got a
evaluation
GED from WCC
I
in
am-
2013 in 3 months, you know I'm competent. You know what I'm saying? Thank you, Judge.
I am going to order a forensic evaluation. I will set a competency hearing just to make sure. I'm going to set that for January 29th, 2025,
January 29.
a.m. I will sign an order to
Can you
that
give me a
effect
PR
at
bond,
this
please,
time.
Judge?
I'm sorry,
Can I please, I would like to request a PR bond.
this time you can file a motion or somebody can file a motion before the court and I'll consider a written motion, but at this time I'm not going to change the bond in this case.
What is the bond?
Currently, your bond is set at $25,000 cash sure.
Do you have any bail bondsman numbers for me that I could get a hold of, please?
Sorry, don't
I
need
can,
those
I'd like to
with me.
subpoena a
You
bail
can-
bondsman
you can
phone
check
number.
with the individuals at the jail. I'm sure they'll be more than happy to assist you in that regard.
And here's the consequence of everything we've seen so far. The court orders a competency exam, keeps the public defender, and refuses to lower the bond. This is the system saying, we're not moving forward until we know you fully understand what's happening. One emotional hearing has now delayed the entire case.
All right, so that you understand, I'm leaving the public defender on the case at this point.
No, I don't want a
Get the
public defender.
evaluation. I hear you, but I'm telling you what I'm doing. We will get the evaluation. I'd suggest that you be cooperative in that. You may be right, it'll come back competent, and then we can get this proceeding moving even quicker.
Not gonna come back, huh? Y'all gonna try to.
Before we go off the record,
Y'all corrupt as hell. Y'all fucked up, people. Y'all people fucked up. Y'all.
Okay, keep moving. All right, been a pleasure.
I'm Benjamin Franklin's son.
Me too.
I just want to.
Because Paris is lovely in this one.
I just want to address one thing, Your Honor, relating to the prosecutor's office's responsibility of providing discovery as we move forward in this case. The defendant, in attempting to represent himself at the PCC on Thursday last week, stated that he didn't need an attorney, he didn't want an attorney, and that he didn't need the discovery either, that he knew what was going on, and that he wasn't worried about having all the video prior to today's hearing, and we were prepared to proceed today. At the same time, under normal circumstances, we would be in the process of getting all of that video discovery to defense counsel that he referenced wanting today. He mentioned wanting the video at the intersection. My office is in the process of getting that hopefully before the weekend. And I'm looking for permission to provide discovery to Mr. Brown's office on this file moving forward.
In response, Your Honor, as we are still on the case, I would ask that they provide discovery as they normally would.
And then if in January, depending on what happens, then certainly that information can be tendered either if he's going to represent himself, which he may be entitled to do, then the public defender can turn it over to the prosecutors we have in other cases can supply it directly to him.
Understood. Thank
All
you.
right. Thank you. At least I wasn't called the Illuminati in this one. Well, that's also called a bunch. It was also called a bunch of other things, but that's okay. I'm good with that. I'm confident in me, so I. Is that your only case, Mr. Brown?
I think it's so long.